Okay, I'm going to read a little bit of this professional responsibility outline produced by Barbie to prepare for the MPRE. I'm just picking up within conflicts involving former clients, and I'm in part 4, clients of former firm. A lawyer's duties may extend not only to the clients she represented personally, but also to clients of the lawyer's former firm. A lawyer whose firm formerly represented a client in a matter and who acquired protected confidential information, Rule 1.6, or information pertaining to the representation, Rule 1.9c, may not thereafter represent another person in the same or a substantially related matter if that person's interests are materially adverse to those of the former client, unless the former client gives informed consent confirmed in writing. And that comes from the ABA Model Rule 1.9b. And what's written here in bold italics is the same or a substantially related matter, and if the person's interests are materially adverse to those of the former client, unless the former client gives informed consent. This is italicized. Informed consent confirmed in writing. So there's an example. We're skipping through that. 5. Disqualification of a lawyer's new firm. If a lawyer who is disqualified from representing a client under the rules set out in 3 or 4 above joins a new firm, the new firm may be disqualified as well unless the lawyer is properly screened, which is in bold italics. For example, the disqualified lawyer does not work on the case, discuss it with those who do or have access to case files, and does not share files or fees from the matter, and a former client is given notice. Okay. Skipping that example. Note, the prohibition against sharing fees does not prevent the lawyer from receiving a regular salary or partnership share set by prior independent agreement. It means only that the lawyer's compensation must not be directly related to the matter in which the lawyer is disqualified. ABA Model Rule 1.10, Comment 8. I'm glad to see this is in the actual ABA Model Rules, I think, because I believe I recorded them just prior to this recording, unless it's coming from another source. So A, under 5, disqualification of the lawyer's new firm is notice and certifications to former client. Reading as follows. Prompt written notice must be given to any affected former client detailing Ruminant 1, a description, 1, 2, 3, 4. So starting with 1, a description of the screening procedures employed. Ruminant 2, a statement of the firm's and the lawyer's compliance with these requirements. Ruminant 3, a statement that review before a tribunal may be available. And Ruminant 4, an agreement by the firm to respond promptly to written inquiries or objections by the former client concerning the screening procedures. The disqualified lawyer and a partner of the firm must provide the former client with certifications of compliance with the ABA Model Rules and with the screening procedures at reasonable intervals upon written request and upon termination of the screening procedures. And this is citing ABA Model Rule 1.10A2. So Ruminant 1 was a description of the screening procedures. Ruminant 2 is a statement that review before a tribunal may be available. That was 3, actually. 2 is a statement of the firm's and the lawyer's compliance with these requirements. Romanet 4 is an agreement by the firm to respond promptly to written inquiries or objections by the former client concerning the screening procedures. A disqualified, and then it just stops there. A disqualified lawyer and the partner of the firm must provide the former client with certifications of compliance with the ABA model rules and with the screening procedures at reasonable intervals upon request and upon termination of screening procedures. Okay, so that's a little bit about screening procedures. Now, part 6 under this section is, and again, the section's conflicts involving former clients, and we're about to move through into, this is the last section before prospective clients. So, disqualification of lawyer's former firm. A lawyer's former firm is prohibited from representing a person with interests materially adverse to those of a client of the formerly associated lawyer if Romanet 1, the matter is the same or substantially related to that in which the formerly associated lawyer represented the client, and Romanet 2, a lawyer remaining in the firm has information protected by Rules 1.6 and 1.9c that is material to the matter. Just reading one more time, a lawyer's former firm is prohibited from representing a person with interests materially adverse to those of a client of the formerly associated lawyer. Again, it requires relating the same or substantially related to the same conflict. Or matter that the lawyer represented the client, the former client. And a lawyer remaining in the firm has information protected under those rules. Example, we're going to skip examples, but for argument's sake, I have ABA's Model Rules of Professional Conduct on my computer. So let's just look at 1.6 and 1.9. 1.6 is confidentiality of information. 1.9 is duties to former clients. And therefore, I would say this incontrovertibly proves that this is the same model rules. ABA model rule is the same thing as the ABA rules of professional conduct. So that's great. So 1.6, the whole thing is actually kind of long. Is there a specific part of this or all of it? That confidential, yeah. The entire section relating, it's client-lawyer relationship. It's within client-lawyer relationship titled Confidentiality of Information, which I have read in a separate reading. There's an A, you're not allowed to reveal. Information relating to representation of a client unless the client gives informed consent. B, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary for like 7 different things. The shorter of those is to prevent reasonably certain death or substantial bodily harm, prevent crime from being committed, which could lead to substantial injuries, to prevent, mitigate, or rectify substantial injury of the financial interests of commission of a crime by the client, and to secure legal advice about the lawyer's compliance with these rules, and to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, to comply with another law, court order, or to detect or resolve conflicts of interest arising from the lawyer's change of employment. So when you can discuss confidential matters, just the extent that you can figure out whether or not there is a conflict. And C, the lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. So if it's like demanded upon subpoena, you should take the matter aside and try not to make it public information to the extent feasible because it's privileged. So, okay, so like getting off track, that's the end of that section, which is conflicts involving former clients, but duties to former clients is Rule 1.9, which if it's short, I'll read that as well. Also part of the client-lawyer relationship, there's an A and a B. A is just saying you formally represented the client, shall not thereafter represent another person for the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client unless there's consent, and a lawyer shall not knowingly represent a person in the same or substantially related matter in which the firm with which the lawyer formerly was associated previously represented a client. There's a 1 and 2, 1 whose interests are materially adverse to that person, and 2 about whom the lawyer had acquired information protected by, again, Rules 1.6 and 1.9c, that is material to the matter unless the former client gives informed consent and confirmed in writing. And C, a lawyer who has formally represented a client in a matter or whose present or former firm has formally represented a client in a matter shall not thereafter 1 or 2, use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client, or when the information has become generally known, or 2, reveal information relating to the representation, except as these rules would permit or require with respect to a client, which I think was part of 1.6 I just read. So, skipping the example, we're going to move to conflicts involving prospective clients. 1, lawyer's duty concerning confidential information. 2, lawyer's duty concerning conflict of interest. And 3, how to overcome a prospective client conflict. So in the first section, lawyer's duty concerning confidential information. A prospective client is someone who consults with a lawyer about the possibility of forming a lawyer-client relationship, ABA Model Rule 1.18a. The attorney-client privilege protects confidential communications between a lawyer and a prospective client. The ethical duty of confidentiality also applies to information learned during a consultation between a lawyer and a prospective client. Thus, the lawyer must not reveal or use information learned from a prospective client unless that exception to the duty of confidentiality applies. There is an example. I'm going to skip through those, but remind myself that there is a graphical depiction of privilege that I should look at before testing. So, number 2, lawyer's duty concerning conflict of interest. Subject to the exception stated in 3 below, a lawyer who obtains confidential information during a consultation with a prospective client must not later represent a different person in the same or substantially related matter if the confidential information would significantly harm the prospective client. This is coming from ABA Model Rule 18c. This conflict is imputed to others in the lawyer's firm, but the imputation can be overcome by screening as stated in 3 below. 3, how to overcome a prospective client conflict. So, one way to overcome the conflict described in 2 above is to obtain informed consent confirmed in writing. From both the affected client and the prospective client. ABA Model Rule 1.18d1. A second way to overcome the conflict is to satisfy all the following conditions, 1, 2, and 3. Romanet 1, demonstrate that a lawyer who held discussions with the prospective client took care to avoid exposure to any more confidential information than was necessary to determine whether to present the prospective client. Romanet 2, demonstrate that the disqualified lawyer is timely screened from any participation in the matter and will not share the fee, but he may take his ordinary salary or partnership share. And Romanet 3, give written notice to the prospective client. So I'm just going to reread the italicized and bold in Romanet 1, which is avoid exposure to any more confidential information than was necessary to determine if there's a conflict. And within Romanet 2, timely screen from any participation in the matter. Now, I opened up Rule 118, which might very well just be carbon copy everything I just read, but this is again in the client-lawyer relationship section of the model rules, and there's A, B, and C. A and B aren't very long, so a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter as a prospective client. So there's a definition. B, even when no client-lawyer relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information except as 1.9 would permit with respect to information of a former client. Now, C is the part that was cited in the lawyer's duty concerning conflict of interest. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that could be significantly harmful to that person in the matter, except as provided in paragraph D. If a lawyer is disqualified from representation under this paragraph, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter except as provided in paragraph D, which D2, I believe, is what cite, or D1 and D2 are cited in the second paragraph I read from the MPRE Outline. So D, when the lawyer has received disqualifying information as defined in paragraph C, representation is permissible if 1, both the affected client and the prospective client have given informed consent, confirmed in writing, or 2, the lawyer who received the information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether they represent the prospective client. And that includes Romanet 1 and 2. 1, the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. And Romanet 2, written notice is promptly given to the prospective client. So that is pretty much precisely what the section says in the outline. F, conflict rules for current and former government officers and employees. When a lawyer serves as an officer or employee of the government for a period and then leaves to enter private law practice, the government has a right to expect that its confidential information will not be abused. Furthermore, private clients should not be allowed to gain an unfair advantage from information known to a lawyer only because of prior government service. The lawyer should not be in a position to benefit private clients because of prior government service. Right. Finally, possible future benefit to private clients should not distort a lawyer's professional judgment while working for the government. See ABA Model Rule 111, Comments 3 and 4. All of the foregoing would suggest that there should be a broad, rigid rule of disqualification for lawyers who move from the government to private practice. However, such a rule would have a serious drawback. Yes, it would. The government would be hindered recruiting good lawyers for short-term government service. Thus, the ABA model rules establish disqualification rules that are relatively narrow and flexible. See Restatement 133, which is interesting that we're going to a restatement now. Like, what restatement? Anywho, in here, Rule 1.11 just cited as special conflicts of interest for former and current government officers and employees. See how long this is. As I continue in the outline, federal and state conflicts of interest laws. both between government and private jobs must comply not only with the ethics rules, but also with various state and federal statutes and regulations. See example, Federal Ethics and Government Act 18, Title 18 of the United States Code, Section 207 through 208. Those are not covered in this outline, but they must be considered in solving an actual problem of successive government and private employment. And number 2 in this section, private work following government work on same matter. Except when expressly permitted by law, a lawyer who leaves government service and enters private practice must not represent a private client in a matter in which the lawyer participated personally and substantially while in government service, unless the government agency gives informed consent. Informed consent confirmed in writing. This is part of ABA Model Rule 111A. Which I find interesting that it's not a restraint on practice, but I guess there's governmental interest for it. So, meaning of the term matter, which it's interesting they define the term matter here. I just want to page over to what Barbary provides as the definition of matter, which you don't see it. Okay, so in the test, probably will not see the phrase that I keep repeating over and over, which is subject matter. The same or substantially, similar? Subject matter, substantially related matter. So the definition here of matter, coming on page 72, is, as used in this rule, matter has a narrow technical meaning. It does not mean general topic or broad subject area. It means specific set of facts involving some specific parties. And the definition of that, looking to come from ABA Formal Op 342, produced in 1975. And also ABA Model Rule 1.11e defines it more fully as any judicial or other proceeding, application, request for a ruling or other determination, contract, claim, controversy, investigation, charge, accusation, arrest, or other particular matter involving a specific party or parties, plus anything else that is covered under the conflict of interest rules of the government agency in question. Which is explains a lot. So I'm just going to make a note to put that on a note card. Matter from page 73, just in the middle of the book here, comes a really pertinent definition. There's examples I'm skipping, and there's a part B within private work following government work on same matter. So you have part B, meaning of personally and substantially. The term personally and substantially means just what it says. A disqualification rule applies only when the lawyer's work on a matter was both personal and substantial. The term does not include work that is trifling, and it does not include mere supervisory responsibility. Shocking. Again, that's citing the same formal op, 342. ABA 1975. Another example, which I'm skipping through to the next page. And you see C, imputed disqualification. So if a lawyer is disqualified as the rule stated above, when everyone in that lawyer's firm is also disqualified unless the lawyer is timely screened from the case. The lawyer does not share fees from the matter, and written notice is promptly given to the governmental agency to enable it to make sure that the above conditions are being met. There's an example, but I'm going to move to number 3. under conflict rules for current and former government officers and employees. So number 3 is subsequent use of information gained during government service, and there's an imputed disqualification section. Number 4 is current government service after private practice. The other way around, ordinary conflict rules apply, personal and substantial rule also applies, negotiating for private employment, and that will end the section with government officers. So for subsequent use of information gained during government service, ABA Model Rule 1.11c provides that except when expressly permitted by law, a government lawyer who receives confidential government information about a person must not later represent a private client whose interests are adverse to that person when the information could be used to the material disadvantage of that person. The rule covers only information actually received by the government lawyer, not information that could be fictionally imputed to the lawyer. Confidential government information means information that is gained under the government authority and which the government is prohibited from revealing or has a privilege not to reveal, and which is not otherwise available to the public. And that is defined in the model rules, which, again, I have read the model rules before, and I remember specifically hearing myself read this. So we're going to skip the example and go directly to imputed disqualification. If a former government lawyer is disqualified by this rule, then everyone in that lawyer's firm is also disqualified unless the lawyer is timely screened from the matter and the lawyer is not apportioned any part of the fee earned in the matter. Again, Rule 11, 1.11c. Skipping the example to 4, current government service after private practice. ABA Model Rule 1.11d states the rules that apply to a person who becomes a government officer or employee after private practice or non-governmental work. A. Ordinary conflict rules apply. The ordinary conflict rules stated in ABA Model Rules 1.7 current clients and 1.9 former clients apply to a lawyer who enters government service after private practice or other non-governmental work. Coming from 1.11 D1. Passing over the example, we go to B. Personal and substantial rule also applies. If a lawyer works personally and substantially on a matter in private practice or other non-governmental employment, the lawyer must not work on that same matter when she later enters government service, whether or not the later work would be adverse to a former client. However, informed consent, confirmed in writing, can solve the conflict. Skipping over the example, Part C, negotiating for private employment. When a person in government service is currently working personally and substantially on a matter, she must not negotiate for private employment with any party or lawyer who is involved in that matter. There is a special exception for judges and adjudicative office law clerks who are seeking work after their clerkships end. That is also coming from the same model, Rule 1.11 D something or other, which I've read in an earlier recording. Skipping over the example, and this brings us to G, which is the last lettered section in Part 4. So I'm going to finish reading this in Part 4 before ending the recording. So conflicts involving former judges, arbitrators, and the like. The conflict of interest problems posed when a lawyer switches between government and private practice are also present when a judge leaves the bench and enters private practice. Thus, the rules discussed here are similar to those discussed above. 1. Switching from judicial service to private law practice. A lawyer must not represent a private client in a matter in which the lawyer has earlier participated personally and substantially while serving as a judge or other adjudicative officer, for example, a referee or special master, or as a law clerk to such person, or as an arbitrator, mediator, or other third-party neutral, unless all parties to the proceeding give informed consent confirmed in writing as per Model Rule 1.12a. However, An arbitrator who is selected as a partisan of a party in a multi-member arbitration panel may substantially represent that party. Skip the examples. There's also a 2, 3, and 4. So 2, screening can avoid imputed disqualification. 3, law clerks negotiating for private employment. And 4, other adjudicative officers negotiating for private employment. So in 2, screening can avoid imputed disqualification. If a lawyer is disqualified under Rule 1.12a, everyone else in the lawyer's firm is also disqualified, unless the following conditions are met. Romanet 1, 2, and 3. 1, the lawyer is timely screened from the matter. 2, the lawyer is not apportioned any part of the fee earned in the matter. And 3, written notice is given to the parties in the appropriate tribunal so that they can ensure that foregoing conditions are met. And 3, law clerks negotiating for private employment. A law clerk to a judge or other adjudicative officer must notify the judge or officer before negotiating for private employment with a party or an attorney for a party in a matter in which the law clerk is participating personally and substantially. ABA Model Rule 1.12b. Law clerks are specially treated because they are usually newly admitted lawyers for whom a clerkship is only a temporary first step in a legal career. And 4th, other adjudicative officers negotiating for private employment. The lenient rule that applies to law clerks does not apply to judges, arbitrators, mediators, third-party neutrals, or other adjudicative officers. They are forbidden to negotiate for private employment with a party or the party for or the attorney for a party in a matter in which they are participating personally and substantially. ABA Rule 1.12b. And so we've reached part 5, which is competence, malpractice, and civil liability on page 77. But I don't believe that I read any of the pages prior to 73 aloud. So I'm going to quickly try to buzz through what that entailed and what I say, for instance, highlighted. So part 1 was regulation of the legal profession. A was sources of regulation. And 1 is the state, which includes courts, which have ethics rules, the American Bar Association model rules, and judicial code. There's case law, and there's rules of court. So under the state, there's also bar associations in Congress and state legislatures. For instance, the state evidence statute. There's also the federal system as a source of regulation, which includes the courts and government attorneys. For the courts, a federal court or agency is also constrained by federal statutes, federal case law, and the rules of that particular court or agency. Part B, no longer discussing sources of regulation. No, we're still in sources of regulation. But instead of 1, the state, or 2, the federal system, there's 3, regulation by multiple states. B is admission to the practice of law. So that is beyond the sources of regulation, but still regulation of the legal profession under Part 1. And this includes the application. Before we get there, we're talking about college and law school, passed the bar, and submitted to a bar admission committee an application for admission, which generally includes proof of good moral character and being sworn in before the highest court of the state. So there's the application, which must be truthfully completed, false statements. The applicant must not knowingly make a false statement of material fact, and failure to disclose information. So part 2 of admission in the practice is the character and fitness, good moral character. There is A, investigative procedure, which includes the burden of proof and duties of the applicant. So the investigative procedure, I guess, inquires into moral fitness. The burden of proof and duties of the applicant is the applicant has a duty to cooperate in reasonable investigations. There's a case here, In re Anastaplo. And then there's procedural rights. So an applicant who is denied admission on the basis of bad moral character is entitled to judicial review, usually by the state's highest court. Now, under character and fitness, after investigative procedure, there's the conduct relevant to moral character. What if underlined is any conduct or charges against the applicant to be considered, including those that were acquitted, any litigation to which the applicant was a party. Now, there's within that section, I suppose, criminal conduct, rehabilitation, concealment of past crimes constitutes moral turpitude, and political activity. So I've underlined under the criminal conduct what moral turpitude is, such as a crime involving intentional dishonesty for the purpose of personal gain, which examples are forgery, bribery, theft, perjury, robbery, extortion, or a crime involving violence, example, murder, rape, mayhem. Within which there's that adolescent behavior and civil disobedience. So I underline youth for a fist fight. Rehabilitation that I've underlined is of his character and a present fitness to practice law. There's a case here, March versus Committee of Bar Examiners. The youth for a fist fight, adolescent behavior that does not necessarily bear on the applicant's current fitness to practice law. And applicant's arrest for nonviolent civil disobedience, see Hallinan versus Committee of Bar Examiners, 1966, which is the year prior to March. So concealment of past conduct, I didn't actually underline anything there. So for political activity, an applicant who refuses to take the oath to uphold the state and federal constitutions may be denied admission because there is a rational connection between this requirement and the practice of law. So we're done with part 2 about fitness, character and fitness in admission to the practice of law. Part 3 is citizenship and residency are not valid requirements. That's a short section. And then we move on to C, regulation after admission. We're talking about regulation of the legal profession. Beyond the sources of the regulation and the application to the bar, there's regulation after admission to the bar. And a lawyer is subject to the applicable law governing such matters as professional discipline, procedure, and evidence, civil remedies, and criminal sanctions. So 1 is what constitutes professional misconduct. And there's like examples A through G, of which I highlighted a bit. So A, violation of the rules of professional conduct. They've given 3 Romanettes. 1, violate or attempt to violate any of the rules of professional conduct. Romanet 2, knowingly assist or induce another person to violate the rules. Or Romanet 3, use the acts of another person to commit a violation. And that comes in ABA Rule 8.4. There's B, certain criminal acts that reflect adversely on honesty, trustworthiness, or fitness of a lawyer in other respects. To constitute professional misconduct, the crime must involve some characteristic that is relevant to the practice of law. For instance, dishonesty, breach of trust, substantial interference with the administration of justice. And most crimes involving violence reflect on the lawyer's fitness to practice law. So Part C, under what constitutes professional misconduct, is titled dishonesty, fraud, deceit, and misrepresentation. Any conduct involving those constitutes professional misconduct, and it need not rise to the level of a crime. For instance, plagiarism, misusing expense accounts. D, conduct prejudicial to the administration of justice. And the examples I underlined were falsifying evidence, improper delaying tactics, frivolous claims are dealt with more specifically in the rules relating to litigation. E, stating or implying ability to improperly influence officials. And F, assisting a judge in violating a judicial code. And G, harassment or discrimination in law practice. A lawyer must not, in conduct related to the practice of law, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, or sexual orientation. There's an exception. A judge's finding that a lawyer exercised peremptory challenges on a discriminatory basis does not on its own establish a violation of this rule. That's the exception. Okay, so the permitted actions, this rule does not limit a lawyer's ability to Romanet 1, 2, or 3, accept, decline, or withdraw from representation, provide legitimate advice or adequacy, as long as it's consistent with the rules, and promote diversity or inclusion aimed at, recruiting, hiring, retaining employees. And 2, duty to report professional misconduct. So beyond what constitutes professional misconduct, which is part 1, we now come to part 2, the duty to report. One element of a self-policing group is that each member of a group must be obligated to report misconduct by other members. Therefore, a lawyer who knows, which is bold and italicized, that another lawyer has violated the rules of professional conduct in such a way that it raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer must report the violation to the appropriate professional authority. Similarly, a lawyer who knows that a judge has violated a code of judicial conduct in a way that raises a substantial question as the judge's fitness for office must report the violation to the appropriate authority. Key definitions of knowledge. While a lawyer may report suspected misconduct, she must report known misconduct. Substantial means a material matter of clear and weighty importance. B, sanctions for failure to report misconduct, and C, exceptions, which is confidential information in lawyers' assistance programs. Then there's a disciplinary process, and 3 under the misconduct section of regulating the profession. And I'm going to bookmark a couple definitions, like knowledge and substantial. So for disciplinary processes of professional discipline, you see A, complaint against a lawyer is considered privileged and thus cannot be the basis of an action like defamation. Then there's B, screening. C, hearing. Due process is required. Application of other rights, burden of proof, decision and review. D, sanctions. So when within the hearing section, due process is required. If there is a hearing on the complaint, the accused lawyer is entitled to procedural due process, which means the right to counsel, proper notice to be heard, introduce evidence, and cross-examine adverse witnesses. You see Henry Ruffalo, 1968. The application of other rights. Evidence obtained through an illegal search, for example, is admissible in a disciplinary proceeding. A lawyer may, however, invoke his Fifth Amendment privilege to refuse to answer questions at the hearing. And no disciplinary action can be taken against a lawyer if it is based solely on that. right to remain silent. Spivak versus Klein, 1967 is the source of that piece. Burden of proof. Burden of proof is on the party prosecuting the charge by a preponderance of evidence, beyond a preponderance of the evidence, but less than beyond a reasonable doubt. Inadmissible hearsay would be excluded. And decision and review. The burden is then on the lawyer to show that the committee's action or recommendation is not supported by the record or is otherwise unlawful. Sanctions, 1, 2, and 3. Private and public reprimand or censure, suspension, and disbarment, which is permanent revocation. However, apply for readmission upon proof of rehabilitation. And other sanctions available include probation, restitution, cost of disciplinary proceedings, and limitations on the lawyer's practice, which is interesting. And 4, choice of law and disciplinary proceedings. There's an example, and in the quote or in the margin I wrote, exam doesn't ask state-specific questions because the example cites states. So anyhow, conflict of interest A, choice of law agreements permitted. What I underlined here is regarding conflicts of interest only, a lawyer and client may enter into an advance written agreement specifying the predominant effect jurisdiction. 5, effect of sanctions in other jurisdictions, which is broken into other states and federal courts. So sister states accept disciplinary action by one state as conclusive proof of the misconduct, but not of the sanctions imposed. See Kentucky Bar Association versus Signer, Florida Bar versus Wilkes. There's also ABA Model Rule for Lawyer Disciplinary Enforcement, 22E. Now, federal courts, competent evidence in a federal proceeding and may it itself be sufficient to convince a federal court to impose a similar sanction. See Henry Rhodes, 1967. Disability proceedings is what comes after the effect of sanctions in other jurisdictions. So incapacitation, impairment, disability proceedings, which result in the disabled lawyer suspension from practice until rehabilitation has occurred, which might involve psychiatric evaluation and diversion into a rehabilitation program. You see here a restatement of Law 3rd governing lawyers here and after the restatement. So that's where what we're referring to as restatement. Okay, great. So now we're in letter D under regulating lawyers. And this is the unauthorized practice and multi-jurisdictional practice. So there's 2 romanettes here. A lawyer is subject to discipline for practicing in a jurisdiction where he is not admitted to practice, and the lawyer is subject to discipline for assisting another person in the unlicensed practice of law. This is Model Rule 5.5a. So 1, naturally unauthorized practice by a lawyer. 2, permissible types of temporary multi-jurisdictional practice. Association with a local lawyer who actively participates in the matter is discussed in 5.5b1. And B, also permissible is a special permission to practice in local tribunal, which is pro hac vice for admission for purposes of this matter only, which is really not supposed to be approved all that often, like maybe once or twice, but rare. Because they want you to be a member of the bar in their state if you're going to practice there. And generally, it does require association with a local lawyer. So anyway, mediation or arbitration arising out of practice in home state. This is letter C within permissible types of temporary or multi-jurisdiction practice. And D, other temporary practice arising out of state practice in home state. And And E, temporary practice by foreign lawyers. There's an ABA model rule on pro hac vice admission. Okay, so number 3, and I guess moving out of the permissible types of temporary multi-jurisdictional practice, which was 2, and 1, authorized practice of a lawyer. There's 3, permissible types of permanent multi-jurisdictional practice, lawyers employed by their only client. So that's like your corporate counsel, I think, for government. And 1, foreign lawyers advising on United States law. Now, B is legal services authorized by federal or local law. So this is B under permissible types of permanent multi-jurisdictional practice. There's A, lawyers employed by their client only. B, legal services authorized by federal or local law, which is rare. So 4, consequences of multi-jurisdictional practice. I've highlighted government lawyer practices under 3A above, may be subject to the second jurisdiction's client security assessments and continuing legal education requirements. 5 is unauthorized practice by non-lawyers. And so this is important to the test. And there's a 1, 2, and 3 under this section after A. The first is A, general considerations in defining the practice of law. So Romanet 1 is whether the activity involves legal knowledge and skill beyond that which an average layperson possesses. And Romanet 2, whether the activity constitutes advice or services concerning binding legal rights or remedies. And Romanet 3, whether the activity is in one traditionally performed by lawyers. 1, activities constituting law practice. And there's a list here: appearing in judicial proceedings, settlement negotiations, drafting documents regarding legal rights like contracts, wills, and trusts, estate plan, low-cost divorce. 2, activities not constituting law practice is scriveners and publishing books. Tax advice is preparing tax returns and questions incidental to the preparation of the returns. Can be done by an accountant or other layperson. So giving advice on tax law would probably constitute the unauthorized practice of law, but not preparing tax returns or questions incidental to the returns. And B and C and D and E and F all follow within, unauthorized practice by non-lawyers. So the consequences of unauthorized practice is sanctions, including injunction, contempt, and criminal conviction from restatement in Section 4, Common A. C is delegating work to non-lawyer assistants. The lawyer must supervise their paralegals, law clerks, and student interns, and delegate work carefully and must be ultimately responsible for the results. D, training non-lawyers for law-related work. A lawyer may advise and instruct non-lawyers whose employment requires a knowledge of the law, example, claim adjusters, bank trust officers, social workers, accountants, and government employees. And E, helping persons appear pro se. A lawyer may advise persons who wish to appear on their own behalf in a legal matter. And F, assisting a suspended or disbarred lawyer. Now, E is a new letter under the section of regulating lawyers, which is responsibility of partners, managers, and supervisory lawyers. 1, 2, 3, 4 are listed right here. Partners' duty to educate and guide in ethics matters. 2, duties of direct supervisor must make reasonable efforts to ensure that the other lawyer adheres to the rules of professional conduct. 3, how duties are fulfilled. And 4, ethical responsibility for another lawyer's misconduct. So Romanet 1, the first lawyer ordered the second lawyer's misconduct or knew about it and ratified it. Or Romanet 2, the first lawyer is a partner or manager who has direct supervisory responsibility over the second lawyer, and she knows about the misconduct at the time when its consequences can be avoided or mitigated and fails to take reasonable remedial action. remedial action. So it kind of takes you back to duties of the direct supervisor. Must make reasonable efforts to assure that the other lawyer adheres. Right. It's incredibly important too. So F, responsibilities concerning non-lawyer assistants. G, responsibilities of a subordinate lawyer. I, restrictions on the right to practice. This is tested a lot. J, sale of a law practice. And K, law-related ancillary services. Before you get to part 2, which is the client-lawyer relationship. So I'm going to fly through the responsibilities concerning non-lawyer assistants. There's 1, duty to educate and guide in ethics matters, duty of partners respecting non-lawyer employees, duties to direct supervisor respecting non-lawyer employees for ethical responsibility for non-lawyers' misconduct. This is broken into 2 parts. The lawyer ordered the conduct or knew about it and ratified it, or the lawyer is a partner manager who has direct supervisory responsibility over the non-lawyer, and the lawyer knows about the misconduct at the time when its consequences can be avoided or mitigated and fail to take reasonable remedial action. I just read that and left a note card there to write that down, but it's in Model 5.3c. Responsibilities of a subordinate lawyer. 1, duties concerning clear ethics violations. It says here, must follow the ethics rules even when acting under the direction of another person. Be relevant in determining whether the subordinate had knowledge that is required for some ethics violation. Right. And 2, that's when the subordinate's working under the direction of the supervisor. Meaning to say that if you're a subordinate lawyer, you know enough to know if your supervising attorney is giving you directions against ethical rules that ought to be followed. 2, duties concerning debatable ethics questions. When debatable ethics, and both people get in trouble too. I don't know why this isn't so. This is only 1 paragraph. This is like critical. Duties concerning debatable ethics questions. Okay, this might be where the meat of this is. Let's just read this whole thing. Orders from a supervisory lawyer are no excuse for clearly unethical conduct. A lawyer must follow the ethics rules even when acting under the direction of another person. This comes from Model Rule 5.2 and Restatement Section 12. However, the fact that a subordinate lawyer will take into consideration a knowledge element. And then 2, duties concerning debatable ethics questions. The subordinate lawyer does not violate the rules of professional conduct by acting in accordance with the supervisor's reasonable resolution of an arguable question of professional duty. When a debatable ethics question arises, someone must decide on the course of action, and that responsibility must rest with the supervisory lawyer. If the supervisor's judgment turns out to have been wrong, the subordinate lawyer should not be disciplined for doing what the supervisor directed. Now, letter H. Professional independence of a lawyer. 1, fee splitting with non-lawyers, temporary lawyers. Except as provided below, a lawyer must not share her legal fee with a non-lawyer. Fee splitting is covered under 5.4a and Restatement Section 10. The purpose of this rule is ill-defined, but it is said to help protect a lawyer's professional independence or judgment. Obviously, the salaries of non-lawyer employees of a firm are paid with money earned as legal fees, but that is not regarded as sharing a fee. Furthermore, a firm can only employ temporary lawyers through a placement agency without violating the fee-splitting rule. Interesting. So, death benefits permitted. Compensation and retirement plans for non-lawyer employees, sale of a law practice, and sharing court-awarded fee and nonprofit organization and partnership with non-lawyer to practice law prohibited. Non-lawyer. So that's number 2. So within fee splitting with non-lawyers, there was all those potential exemptions that I just listed. like death benefits, compensation and retirement plans, sale of the law practice, and sharing court-awarded fee with nonprofits. 2, under the professional independence of a lawyer, is partnership with non-lawyer to practice law is prohibited. So a lawyer must not form a partnership with a non-lawyer if any of the partnership activities will constitute the practice of law. I'm reading the example here because this I find so difficult to understand. Family lawyer F formed a partnership with marital psychologist P. Their purpose was to offer a full range of counseling and legal services to family clients. All the legal work was done by F and all of the other counseling done by P. Neither transgressed into the domain of the other. Nevertheless, F is subject to discipline because part of the partnership activity constitutes the practice of law. So you just can't merge like that. Non-lawyer involvement in incorporated firm or other association. A lawyer must not practice in an incorporated law firm or association authorized to practice law for profit if 1, 2, or 3. 1, the non-lawyer owns any interest in the firm or association, but when a lawyer dies, her estate may hold an interest during the administration of the estate. 2, that a non-lawyer is a corporate director or officer or the equivalent thereof. Or 3, a non-lawyer has a right to direct or control the professional judgment of a lawyer. And that's all covered in Model 5.4. So remember, the important thing here is it's a non-lawyer involvement in the incorporated firm or other association. So I think this means you can't have a non-lawyer like on your board. Interference with lawyers' professional judgment. Restrictions on the right to practice. So a lawyer must not allow a person who recommends, employs, or pays her for serving a client to direct or regulate the lawyer's professional judgment. Got it. Restrictions on the right to practice. This is very important. So 1, restricted partnership and employment agreements. 2, restrictive settlement agreements for clients. See ABA Formal Op 93-371 from 1993. So a lawyer must neither make nor offer an agreement in which restriction on the lawyer's right to practice as part of the settlement of a client controversy. And the first one, restricted partnership and employment agreements, a lawyer must neither make nor offer a partnership or employment or similar agreement that restricts the lawyer's right to practice after termination of the relationship unless you're the government, which apparently can. Unless non-compete associated with the sale of the practice is what I've written in the margin here. Because sale of practice is letter J within the regulation of the profession. And so you've got Romanet 1, the seller must cease to engage. I'll just read this whole thing because it's a little tricky. Model Rule 1.17 permits a sale of a law practice or a field of law practice, including goodwill, under certain circumstances. Pursuant to this Rule 1, the seller must cease to engage in the private practices of law or in the sold field of practice in the area where the practice has been conducted. Romanet 2, the entire practice or the entire field of practice must be sold to one or more lawyers or firms. And Romanet 3, written notice must be given to the seller's clients regarding the sale, the client's right to retain other counsel or to take possession of their files. In fact, the consent to the transfer of the client's files will be presumed if a client takes no action within 90 days of receipt of the notice. If notice cannot be given to a client, a court order is required to authorize the transfer of the representation of that client to the purchaser. Letter A, under when a sale is permitted, selling lawyer may practice in limited circumstances. So this is one of the only times that the right to practice can be restricted. And it's if you're selling your practice and you're making some non-compete agreements, probably for a temporary period. Protection of sellers' clients after sale. the purchaser must undertake all client matters in the practice, not just those where they're going to earn substantial fees. So, letter K, law-related ancillary services. Planning, accounting, lobbying, trust services, real estate counseling, providing title insurance, and preparing tax returns. For example of law-related services. 1, non-legal services and legal services provided together. Pretty sure that's wrong. Can't do that. If a lawyer provides non-legal services in circumstances that are not distinct from her provision of legal services, then the rules of professional conduct apply to both the legal and non-legal services. Okay, so you can do it. It's one of those things I just mentioned. And yet, these rules apply to both sides of the house. 2, non-legal services provided by entity that is controlled by the lawyer. 3, providing non-legal services to clients. When a client-lawyer relationship exists between the lawyer and the individual receiving the law-related services, the lawyer must comply with Rule 1.8a, which specifies the conditions the lawyer must satisfy when she enters into a business transaction. The terms of the transaction must be fair to the client. The terms must be fully disclosed in writing, covering the essential terms of the transaction and the lawyer's role in the transaction. Client must be advised in writing that he should seek advice from an independent lawyer regardless of the arrangement, and the client must be given informed consent in writing signed by the client. So the client-lawyer relationship is part 2 of this outline, starting on page 22. And 1, how the relationship is formed. 2, duty to reject certain cases. 3, duties owed to prospective client, and 4, ethical obligation to accept unpopular cases. So I've underlined a lot here. How a relationship is formed. 1, a person manifests an intent that the lawyer provide legal services and the lawyer agrees, which is what's underlined. And 2, reasonably relying on the lawyer to provide the services. So the person manifests an intent to have the lawyer represent him, and the lawyer fails to make clear that he does not want to undertake the representation. The lawyer knows or should know the prospective client is reasonably relying on the lawyer to provide the services, or a tribunal appoints a lawyer to represent the client. This comes from Restatement 14. Now there's an implied assent and reasonable reliance. The lawyer's assent is implied when he fails to clearly decline representation and the prospective client reasonably relies on the representation. The reason is a question of fact. So then there was duty to reject. Client's motive is harassment, being A. B, unsupportable factual or legal position. If factually or legally frivolous, a position is not frivolous if the lawyer can make a good faith argument that the facts are as claimed or the present law should be changed. Lawyer does not have all the facts at hand at the outset, but expects to develop them during discovery. And C, lawyer not competent, too busy, or inexperienced. And D, strong personal feelings which impair the ability to effectively represent the client. E, impaired mental or physical condition would materially impair his ability to represent the client. Like I said, duties owed to prospective clients. There's 1, protect the prospective client's confidential information, which includes declining to represent other clients in the same or related matter, and the confidential information would be harmful to the prospective client. 2, protect any property a prospective client has given the lawyer. And 3, use reasonable care in giving the person any legal advice, such as whether the claim has merit, whether conflicts of interest exist, and when the action must be commenced. Statement 15. For ethical obligations to accept unpopular cases, there's an obligation to accept a fair share of unpopular matters or indigent or unpopular clients. Then there's C, attorney's fees. And we're in the client-attorney relationship section. This is going to be an area to re-review. I'm going to mark it. I'm only going to read the section titles. I'm not going to read everything, but you really have to write a contract. Bargain at arm's length. Thus, in fee disputes, courts strain to give the benefit of doubt to the client. One must communicate fee arrangement to the client. A writing is preferable. It is generally not required, except in California, and in contingent fee agreements. The lawyer also has an ongoing duty to communicate any changes regarding the fee arrangement. Exception, regularly represented client, which is on basis or a rate, and the supplemental memorandum that is an example, sorry. 2, discipline for unreasonable fee. Here's the factors for the reasonableness of a fee. 1, time and labor. 2, novelty and difficulty. 3, skill. 4, work for the client will preclude the lawyer from doing fee-paying work for others. 5, fee customarily charged in the locality for similar work. 6, amount at stake and the results obtained for the client. 7, time limitation is imposed by the client or other circumstances. 8, the nature and length of the relationship. 9, the experience, reputation, and ability of the lawyer performing the services. And 10, whether the fee is fixed or contingent. Contingent fee can be higher because it requires the lawyer to make a gamble. This comes from ABA Model Rule 1.5a. B, items that may and may not be billed. Actual cost of the attorney is the only thing here that's in bold and italics, but we're looking at special services such as photocopying, long-distance calls, computer research, special deliveries, secretarial overtime, and the like. So that's the staffing, equipping, and running the attorney's office. No overcharging for services provided by third parties, such as court reporters, travel agents, and expert witnesses. Furthermore, an attorney must not double bill for her time. Collecting and financing attorney's fees, payment in advance, true retainer fee, refund any unearned part of the advance if she is fired or withdraws. If the payment is in advance. Be careful to distinguish a true retainer fee from a payment of a fee in advance. A true retainer fee is money that is paid solely to ensure the availability of the lawyer, and the lawyer who is fired or withdraws generally need not refund the retainer fee. Examples: property for services, cutting off services, credit arrangements, and security. Those are the last sections under collecting and financing attorney's fees. Contingent fees. So for credit arrangements and security, it says the lawyer may permit the client to pay a legal fee by credit card, finance fees through bank loans, contractual attorney's lien to secure the payment of the fee when permitted by local law. So contingent fees, the lawyer collects the fee only if the matter is resolved in a client's favor as a percentage of the client's eventual recovery. There's some other things I marked here. Some states have set statutory limits on the percentage of the contingent fee. When contingent fee is prohibited in criminal cases and domestic relation cases, such as securing a divorce, amount of alimony or support, or the amount of property settlement. There is an exception for recovering money that's past due under an alimony or support decree under Section 1.5 of the Model Rules. B, contingent fee must be reasonable. C, writing requirement for contingent fee agreements, which we discussed. So not all agreements need to be in writing unless it's contingent or it's in California. Now, a Romanet 1, 2, 3, and 4. 1, calculate it, how it's calculated. What's deducted first. What litigation and other expenses are to be deducted from the recovery, whether deductions for expenses will be made before or after the contingent fee is calculated, and what expenses the client must pay whether or not she wins the case. Fee disputes, see Restatement 41 in general, section, and B, remedies, which include 1, liens, 2, retention of funds in trust accounts, 3, arbitration and mediation. So it's here that you see to retain the disputed amount in a client trust account. You can release what's not in dispute. So number 6 is fee splitting with other lawyers. Number 6 under collecting and financing attorney fees. Fee splitting with other lawyers. The rule is designed to prevent lawyers from becoming client brokers and to discourage excessive fees. A, lawyers within a firm. B, separation and retirement agreements. That has to do with like a law firm may make payments to a former partner and associate under a separation or retirement agreement. C, certain splits with lawyers outside the firm. If the total fee is reasonable, split is in proportion to the services performed by each lawyer or some different proportion if each lawyer assumes joint responsibility for the matter. And 3, if the client agrees to the split in a writing that discloses the share each lawyer will receive. So the client must know what each lawyer is receiving. And it has to be in writing. 7, true referral fees are unethical. Prohibits a lawyer. 7.2b prohibits a lawyer from paying anyone for recommending him or referring a matter to him. Reciprocal referral agreements with another lawyer or a non-lawyer professional. And that's all I'm going to say about that. D, scope and bounds of representation. In the client-attorney relationship, there's implied authorization to act. 1, may limit the scope of representation. The limitation is reasonable under the circumstances. And 2, the client gives informed consent. 2, must not assist client in crime or fraud. Telling client no. B, discussing proposed conduct. C, discovering a client's illegal conduct. What if I underline in these 3 sections is explain why you cannot do what the client expects. Lawyer must not recommend illegal conduct or instruct the client on how to break the law and get away with it. And if a client insists on illegal or unethical assistance, the lawyer must withdraw from representation. This is in Model Rule 1.16a and is what you need to look into the LLAMAs acronym. C, discovering client's illegal conduct. When a lawyer discovers that a client has begun an illegal course of action and the action is continuing, the lawyer must not assist in the wrongdoing. The lawyer must withdraw. There's a noisy withdrawal in which she gives outsiders notice of withdrawal and disaffirms any of her prior opinions, documents, affirmations, or the like that the client is using to carry out the wrongdoing. 3, decisions to be made by the client. This is in the scope and bounds of representation in the client-attorney relationship section. This is going to include at least 5 things, which is whether to accept a settlement offer, what plea to enter in a criminal case, whether to waive a jury trial, whether to testify in a criminal case, and 5, appeal, whether to appeal. This comes in ABA Model Rule 1.2a, Restatement Section 22. Disagreements between a lawyer and client can be on the issues of law, tactics, and strategy, and if you cannot resolve your agreement, you may withdraw, or the client may fire the lawyer. This is covered in Model Rule 1.16a, 3, and b4. Fourth is the lawyer's authority to bind the client. The lawyer's actions on behalf of a client will legally bind the client if the lawyer acted with actual or apparent authority. A, actual authority, lawyer's belief. B, apparent authority, third party's belief. Within that section, the court or third party reasonably assumes that the lawyer has the authority to act based on some manifestation from the client. 1, how client creates apparent authority. C actually is the ratification, and D is when the lawyer's authority ends. There's a 1 within that. Well, there's fired or withdraws, client dies, or lawyer dies, all in bold italics. And 1 must notify third parties relying on the authority, probably of the authorities ending, coming to an end. Now 5, client with diminished capacity. There's the lawyer's duties, protective action, and appointment of guardian in B. And 6 is emergency legal assistance to non-client with serious diminished capacity, which diminished capacity rendering immediate and irreparable harm to her health, safety, or financial interest. The lawyer may take legal action on her behalf despite her inability to establish the lawyer-client relationship or make express Okay, so there's the lawyer responsibilities and no compensation for the lawyer. Normally, a lawyer would not seek compensation for emergency actions taken on behalf of the non-client. Communicating with the client is letter E in the client-attorney relationship section. 1, matters that require informed consent. 2, information about status of the matter and means to be used, such as admitting mistakes. 3, requests for information. 4, consultation about illegal or unethical conduct. 5, special circumstances. 6, withholding information from the client, such as court rule or order, or at least within that section comes a court rule or order, and that's all there is. In section E, which is about communicating with the client. So matters that require informed consent, I'm going to go back to this because it's incredibly short. It says the lawyer must promptly inform the client of any decision or circumstance that requires the client's informed consent. Informed consent means that the client agrees to a proposed course of conduct after the lawyer has sufficiently explained the material risks. Admitting mistakes under information about status of the matter and means to be used. The lawyer must inform a current client if the lawyer believes he has materially erred in any representation of the client. An error is considered material if a disinterested lawyer would conclude that it is reasonably likely to harm or prejudice the client. Ruminant 2, even in the absence of harm or prejudice, it is of such a nature that would reasonably cause the client to consider discharging the lawyer. For one more sentence, for what it's worth. However, once an attorney-client relationship is ended, the lawyer has no obligation to inform the former client of material errors discovered after the fact. And that comes from ABA Formal Op 481, 2018. So contracts concerning client-lawyer relationship. Client may avoid the contract in the following circumstances. Restatement 14, contract not made at outset, contract made after work completed are the 2 examples. Now, that's a short section because we're now in G, terminating the lawyer-client relationship. Client fires attorney. So it looks like, and then the others is the lawyer must withdraw, and in some situations, the lawyer may withdraw. And this is covered in restatement section 32. So when the client fires the attorney, there's A, client liability for fees, B, contingent fee cases, and 2, the court permission to substitute attorneys, mandatory withdrawal, is the next section. Disability or illegal or ethical violation. Permissible withdrawal or permissive withdrawal for any reason. Attorney may withdraw for any reason without material adverse effect on the client's interest if the client consents. That's got to be mutually agreed upon. And the client persists in criminal or fraudulent conduct. The client has used attorney services to commit past crime, fraud. Client objective is repugnant or against the lawyer's beliefs. Client breaks promise to attorney. Financial hardship for attorney. Client will not cooperate. Other good cause. Now, 5, attorney's duties upon termination of representation. They're covered under ABA Model Rule 1.16, providing the client reasonable notice of the withdrawal, providing the client with time to obtain another attorney, and refunding attorney's fees paid in advance and not yet earned, and expense advances not yet spent, and returning all papers and property to which the client is entitled. So now we're at Part 3, client responsibility. And I'm just so glad that, I don't know, I didn't understand this so much before the professional responsibilities class, but now I get it after the class is over. All of these are testable sections. So, and they're all like, I think, major sections of the model rules. Client confidentiality is Part 3. Also a major section of the model rules. So there's the general rule. A lawyer may, however, reveal such information if the client gives informed consent or if the disclosure is impliedly authorized to carry out the representation, which might be happening in like negotiations. So that's the general. There's a general rule: the lawyer must not reveal any information relating to the representation of the client. And then there's those 2 exceptions I just said. The rationale of the ethical duty is that it encourages candor between the lawyer and the client, encourages the client to seek early legal advice, and helps the lawyer discover all the information relevant to the client's legal problem. See Model Rule 1.6, Comment 2. Now, B is the relationship between the ethical duty of confidentiality and the attorney-client privilege. 1, compulsion versus gossip. 2, kinds of information covered. 3, disclosure versus use. I haven't underlined anything in these sections. So moving on to C, the summary of attorney-client privilege. There's a basic rule. It also says see restatement 68 through 86. Just a lot of sections. Client is defined. Corporate clients. The employee communicates to the lawyer at the direction of the employee's superior. The employee knows that the purpose of the communication is to obtain legal advice for the corporation, and the communication concerns a subject within the scope of the employee's duties. I'm going to put it. When the client is a corporation, the privilege. Okay. So privilege of corporate clients is a little bit special. Because it's not like the attorney protects each and every one of its employees. It protects the corporation. So there's 3 things that are important there. So attorney is defined. Communication looks to be defined. Within communication, there's the mechanical details of the relationship. There's the pre-existing documents and things. And Part 5, confidential, is defined. Within that, there's the presence of a third party and eavesdroppers. And 6, client is the holder of the privilege. They can waive that privilege. Client puts legal services at issue. Is a subpart under the waiver of the privilege. And B, lawyer's duty to invoke the privilege is also under number 6. Client is the holder of the privilege. So number 7, duration of the privilege. Number 8, exceptions to the privilege. 9, related doctrine of work product immunity. So I'm going to read the exceptions to the privilege, and I'm going to read about work product immunity. Modern evidence law provides several exceptions to the attorney-client privilege. The privilege does not apply if the client seeks the attorney's services to engage in or assist a future crime or fraud. See Restatement 82. The privilege does not apply to a communication that is relevant to an issue of breach by either the attorney or the client of the duties arising out of the attorney-client relationship. And C, the privilege does not apply in civil litigation between the two persons who are formerly the joint clients of the attorney. D, the privilege does not apply in a variety of situations in which the attorney furnished the evidence about the competency or intention of a client who has attempted to dispose of property or by will or inter vivos transfer. And then the work product is material prepared by the lawyer for litigation or in anticipation of litigation. Is immune from discovery, other compelled disclosure, unless the opposition shows a substantial need for the material and the inability to gather the material without undue hardship. A lawyer's mental impressions or opinions are immune from discovery or compelled disclosure, regardless of the opposition's need, unless the immunity has been waived. Now, D is ethical duty of confidentiality and its exceptions. 1, duty not destroyed by presence of a third party. 2, exceptions of the duty of confidentiality, to the duty of confidentiality. A, within the exceptions, the duty of confidentiality is the client's informed consent. B is implied authority. C is the disclosure to prevent death or substantial bodily harm. D is the disclosure to prevent or mitigate substantial financial harm. E is the dispute concerning the attorney's conduct. F, disclosure to obtain legal ethics advice. G, disclosure to detect and resolve conflicts of interest. H, disclosure required by law or a court order. And I underline nothing in that section. 3, protecting confidential information. And the lawyer's got to do reasonable efforts to protect the client's confidential information. I think we just read this. Conflicts of interest is part 4, which is where we were, where we got to. So there's 20 more pages to get to where we started in this recording. Letter A, under conflicts of interest, the general rules concerning conflicts of interest. 1, consequences of a conflict of interest. 2, imputed conflicts of interest, meaning of a firm, and is defined within imputed conflicts of interest. And B, exceptions to imputed disqualification. 1, conflict based on uniquely personal interests of lawyer. And 2, specific situations involving the lawyer's former dealings, screening, and notice. Letter B, under conflicts of interest, is conflicts of interest current clients. 1, concurrent conflicts of interest. This is really important. So I'll read ruminant 1 and 2. The representation of one client will be directly adverse to another client, or ruminant 2, there's a significant risk that the representation of one client will be materially limited by the lawyer's own interest or by the lawyer's responsibilities to another client, a former client, or a third person. This is contained in Model Rule 1.7. Informed consent can solve some conflicts. So I'm glad they're going into this. A within that section is that consent must meet reasonable lawyer standard. Some things are unconsentable. See Rule 1.7. B, consent must be informed. And C, consent must be confirmed in writing. So Romanet 1, there is a tangible or electronic record that is physically or electronically signed by the client. 2, Romanet 2, there is an oral consent that is promptly memorialized and a tangible or electronic record that is promptly sent to the client. And that's it. 1 is the rationale. The writing requirement has 2 purposes. It helps impress on the client that the consent to a conflict is a serious matter. And 2, it helps avoid later disputes that might arise if there were no writing. D must not be on both sides of the litigation. And E, revocation of consent. F, consent to future conflicts. only when reasonable and the client truly understands. 3, so we've gotten past 2. 2 is heavy. 2 is informed consent can involve some conflicts, can solve some conflicts. 1 was concurrent conflicts of interest. Now 3 is specific conflict situations concerning direct adversity between clients' interests. So they're directly adverse. That's when a lawyer is prohibited from representing one client whose interests are directly adverse to another client unless both of the affected clients give their informed consent confirmed in writing. Direct adversity is explained in a really long example. Now, A is unnamed members of a class do not count as clients. 4, specific conflict situations concerning material limitation. I have no idea what this means. And it seems like a really long section. As discussed in 3 above, concern conflicts caused by direct adversity between the interests of 2 clients. ABA Model Rule 1.7 also covers the second kind of conflict, situations in which there is a significant risk that the lawyer's representation of a client will be materially limited by the lawyer's own personal interests or by the lawyer's responsibilities to 1, a different client, 2, a former client, 3, a third person. When there is such a risk, the lawyer must not take on the matter or must withdraw unless each affected client gives informed consent confirmed in writing. Illustrations of the material limitation conflicts are discussed in A through E below. A, representing multiple clients in the same matter. B, representing 2 clients with inconsistent legal positions in 2 unrelated cases. C, conflicts caused by the lawyer's own interests. D, conflict between client's interests and third person's interests. And E, conflicts raised by liability insurance. So within each of A through E, there's some subparts. So within A, reading it again, representing multiple clients in the same matter. There is 1, co-parties in criminal litigation. Ordinarily, a lawyer should not try to defend 2 people in a criminal case. 2, co-parties in civil litigation. 3, non-litigation matters. 4, handling multiple representation conflicts. This is a long section. In both litigation and non-litigation matters, there is a 4-step guide for handling the situation. First, the lawyer should analyze the facts of the case and the applicable law. If she concludes that she can effectively represent both clients despite their potential conflicting interests, then she can move to the second step. 2, second, the lawyer should disclose the potential conflict to each client and explain how it can harm each client, the reasonably available alternatives and disadvantages of having only one lawyer for the 2 of them. 3rd, when the clients fully understand the situation, the lawyer may invite their informed consent to the joint representation and confirm such consent in writing. 4th, if the potential conflict eventually ripens into a present conflict, the lawyer must repeat steps A through C above. The lawyer must withdraw from the joint representation if a reasonable lawyer would have to advise either of the 2 clients not to consent. The lawyer may continue to represent one of them, but only if the client who is dropped gives informed consent to the continuation confirmed in writing. 5, specialty problems for representing more than one client. Within that, there's an A, confidentiality and privilege problems. The next B is basically part of what we're saying are specific conflict situations concerning material limitation. There was representing multiple clients in the same manner. I just went through 1 through like 5 or something like that. And now we're at B, representing 2 clients with inconsistent legal positions in 2 unrelated cases. And that's what it is. You move on to C right after that. 3 paragraphs, which is conflict caused by lawyers' own interests. Again, in the part of specific conflict situations concerning material limitation. There's the lawyer's own interests, 1 and 2. lawyers' financial interests, lawyers who are close relatives is 2. Then there's D, again, explaining the specific conflict situations concerning material limitations. There's D, conflict between client's interests and the third person's interests. That is only a paragraph long. E, conflicts raised by liability insurance, which is policyholders' interests is 1, 2, insurance company's interests, 3, whom does the defense lawyer represent, and 4, conflicts between insurance company and policyholder. A within 4A is the event covered by the policy. 4B, settlement within the policy limits. 4C, settlement controlled by insurance company. 4D, unreasonable limits on defense fees and expenses. Then you get to C, which is conflicts of interest, specific rules for current clients, which I feel like I already entered that section, but we're at C. 1, misuse of clients' confidential information. C1A, use to benefit lawyer or someone else. B, possible civil liability even when client is not disadvantaged. And there's 2 under the conflicts of interest specific rules for current clients. Beyond the part of misusing the client's confidential information, then there's 2, business transactions with the client and money or property interest adverse to the client. Within 2, A, statement of the rule, and B, outer limits of the rule. Now, in statement of the rule, there's a Romanet 1, 2, and 3. The terms of the business transaction and the terms on which the interest is acquired are fair to the client, fully disclosed in writing in a manner that the client can reasonably understand. Of the essential terms of the transaction, the lawyer's role, and whether the lawyer is acting as the client's lawyer in the transaction. And 3, the client is advised in writing that he should get the advice of an independent lawyer about the arrangement before entering into it, and given a reasonable chance to obtain that advice. And 4, the client gives informed consent in writing that the client signs. So 3rd, proprietary interest and subject of limitation. That's the 3rd part within the conflicts of interest with the current clients. Within that, A, 3A, contingent fee exception. 3B, attorney's lien exception. Now, 4 in the current client's duties in the conflict of interest section is gifts to a lawyer from a client who is not a relative. 4A, soliciting substantial gift. 4B, preparing legal instrument that creates substantial gift. And 4C, lucrative appointments. Then there's number 5, acquiring literacy or media rights concerning the client's case. 6, financial assistance to the client in litigation. Within 6, there's 6A, advancing litigation expenses. 6B, paying costs and expenses for an indigent client. And 6C, other financial help is prohibited. So you can't pay their rent, basically. 7, aggregate settlement agreements. Within that section, there's a Romanet 1 and 2. I'm just reading the bold. The clients have come to an agreement among themselves. Romanet 2, disclose to each client all the terms. Romanet 3, writing signed by the client when they give informed consent to the aggregate settlement agreement. Now, under aggregate settlement agreements, there's A, class action settlements, and B, aggregate settlement of criminal case. And then there's 8, number 8, compensation from third parties. Romanet 1, the client gives informed consent. Romanet 2, the third person does not interfere with the lawyer's independence or the representation of the client. And Romanet 3, the arrangement does not compromise the client's confidential information. 9, sexual relationship between the lawyer and the client. Impossible. 9A, no imputation. 9B, pre-existing relationship may still cause conflict. So D is conflicts involving former clients. So we're almost to where we started. There's 1, continuing duty of confidentiality. 2, continuing using confidential information to former client's disadvantage. 3, opposing former client in a substantially related manner. Within 3, there's A, meaning of substantially related matter. 4, clients of former firm. They're substantially related matter. 5, disqualification of the lawyer's new firm. 6, disqualification of lawyer's former firm. Just realize under disqualification of lawyer's new firm, unless the lawyer's properly screened, is written in bold, but notice and certification to former client is a subpart in that section. And then we get to E, conflicts involving prospective clients on page 71. And since this is starting to look really familiar, I'm going to say that's right where we started reading in this recording of the MPRE Outline. And we got all the way through to page 77, which is going to start our next recording on competence, malpractice, and civil liability, which is part 5. Just reading on to see what is part 6. Actually, I'll look at that from the table of contents, just in case we don't know, in case things should happen that prevent reading this outline before the test. Part 6 has to do with litigation and other forms of advocacy. Which is like pretty broad. Part 7, transactions and communications with persons other than clients. On page 100. 8, different roles of the lawyer. Part 9, safekeeping funds and other property. Part 10, communications about legal services. Both of those sections are really important. Those last 2 sections. I don't know about the other roles of the lawyer. The whole trial thing, unless that talks about the exculpatory duty on the prosecution. Seeing if there's 11. I might skip to 11, but judicial ethics is part 12, which I hear is also on the exam. Which is like gotta be really long for like not a lot of benefit to anything besides report judges for doing something wrong. Seems to be a requirement. Let me see, where is subpart 11? There was the communications. Is that 11? Oh yeah, something about legal services. Probably communication about legal services. I want to say advertising. So probably definitely want to read 10, 11, and 12.